Hello and welcome to Absolute Trust Talk. This is our live streaming podcast at Absolute Trust Counsel. I'm Kirsten Howe here with Madison Gunn. And today we are going to be talking about what we call estate planning myths. Madison and I both meet with new clients every week who sometimes are surprised to learn some of the things we tell them. They had, for some reason, a misunderstanding about the law or how things work. Maybe they read something on Twitter, who knows? And we thought it would be fun and interesting to show, it would be an interesting episode if we kind of gathered up some of the most common myths that we hear about from our clients. Some of these are things that people really just need to know, even if they aren't doing estate planning or aren't involved in the estate planning process, but they are related to estate planning in some way. And so we're calling them estate planning myths. And we are now going to debunk them. So, Madison, where do you want to start?
All right. Well, the first one, or the one I think we see the most common, especially if we get someone that comes in that has an existing estate plan, is that once they sign their trust with their attorney, they're done.
Yeah.
They're done. That's it. Don't have to think about it anymore.
Everything's taken care of. Yes. Which is not true because
you have to fund it, or which is putting all of your assets into your trust, which goes beyond just listing the assets in the document itself, but actually retitling those assets. So if it's Kirsten Howe, trustee of the Kirsten Howe Trust, that's what your bank account has to say, or that's what your house has to say, your deed on your house. It's not just the Schedule A on the back of your trust lists those assets, but you have to go to where those assets are held, the bank, the county for the house, a business, if you own a business, and change those assets where they reside.
Right. And also, you got to keep it funded. You initially, right out of the gate, you change the title on everything. But, we all go through life and we open new bank accounts, we switch banks, we do various things, or we buy a different house. So you still have to pay attention to the funding. And there's always legal work when somebody dies. You're not done. It just makes that legal work a lot faster and more efficient, but there will be legal work when somebody dies. So people need to realize that. And I think that, a lot of times, well, you know what I'm talking about. We see surviving spouses come in and they had a joint trust with their spouse who died 6 years ago, and they never did anything after the spouse died. So whenever somebody dies, go see your attorney. Just do it.
Sometimes the trust has a lot of work to do after the first spouse passes away. It might just be the nature of your trust. If it's old or doesn't work well with the current tax laws. So a lot of people are usually surprised to hear that they have to do anything after their spouse dies, or even after a loved one dies. They're just like, I can just divide it all up, right? And be done. And people are surprised to understand that there's a legal process involved.
Right. There is a legal process. Okay. I guess I'll jump in. Another one that we hear sometimes is that clients talk about common law marriage. Oh, we've been together for 10 years, so that's a common law marriage, right?
Yeah. No. Some states might have common law marriage. I remember hearing as a kid people talk about, because I grew up in the era of everybody had divorced parents. So, if the parent had remarried, but they didn't get married, they just been living together for I remember hearing 7 years or 10 years. They've been living together as husband and wife, portraying themselves as husband and wife for a certain period of time. They're considered married under common law, which would get them community property privileges. And that is just not the case in California. You have to have a marriage certificate or a registered domestic partnership.
Right. So yes, there are other states, for example, Texas is the one I hear about most often, that recognize common law marriage. We do not have that in California.
Yeah. And just to point out, that's important to note, because if you've been with someone for 25 years and everything's intertwined and you're not married, it is going to be quite the pain to unravel that if you break up. I mean, not to be a negative Nancy in the sense that we're talking about, with marriage, the point of marriage is the benefits you get conferred upon you upon divorce. So it's that's a benefit, that there's a law and a procedure, but there's not if you're not married.
For when you unwind. Yeah. And I mean, more to the point for us, if just because you've been together for 25 years doesn't give you any right to anything when the other person dies.
Right.
Whereas a marriage would. So you just need to know there is no common law marriage in California. What's next? What do you want to talk about next?
The next one that I have is, I get it all the time, and that is that the minute you set up your revocable trust, you are protected from creditors if you get sued.
Right. So the revocable trust, which is what we use in estate planning, just in the foundational estate planning, if someone says to you, yeah, I have a trust, I did estate planning, it's a revocable trust. And that means that you, as the owner of that trust, you can do whatever you want. You can buy and sell assets. You can spend the assets. There's no restrictions on you. And so the legal system treats all of that property as your property, meaning it's not protected from your creditors. That's just not how it works. So the basic estate planning trust is not designed to provide you with creditor protection.
Yeah. You still need a basic estate plan, even if you're worried about creditor protection, right. But that would just be a separate conversation. That's a
different thing. Yeah. Okay. Okay. Here's one that this is important. This is important. My estate plan will be private until I die. That is to some extent true. It is often true, but it's not across the board true. And so there are a couple of things that people need to know there. Madison, you want to talk about that?
Yeah. The first one is, there's a new law that states that if you, as the settler of the trust or the creator of the trust, it's revocable typically until you die. And then obviously you can't revoke it anymore. But the new law says that if you become incapacitated, it's now irrevocable because you don't have the capacity to revoke the trust. So the law previously states that if you die, your trustee has to send out a notice to all the beneficiaries and your legal heirs, which may not be the same people, and anyone named in your trust, a copy of the trust and a notice showing who the new trustee is. Now they have to do that when you're incapacitated, which means you could still be alive. You could still be fairly cognizant, but you just don't have the capacity to manage your finances. And now your entire family knows what your estate plan is.
Yeah. And the other situation is with a married couple. In some trusts, when one spouse dies, part of the trust becomes irrevocable. And that's the thing that triggers the exact thing that Madison just was talking about. A notice goes out to all the beneficiaries and to your heirs at law, which may be a whole different list of people. So when one spouse dies, it might be the case that that notice goes out and everybody now knows what your trust does. So, you got to keep that in mind. Sometimes we do planning outside of the trust in order to avoid that. And that's also possible. Okay, I'm going to let you take the next one.
The next one's my favorite because I see it a lot, a little bit more than I hope that I would see it. And that is that people are under the false belief that they can continue spending money from the decedent's account. So like, let's say your mom, because you have power of attorney. So you have power of attorney over mom. Mom, you've been able to spend the money on her behalf, and then she dies. And then you keep spending the money because you're listed as a power of attorney.
Right. Powers of attorney, they die when the person who created them dies. Once they're dead, the power of attorney has no legal effect. So you got to stop spending money out of your mom's account when she dies if all you have is a power of attorney.
And you probably have a legal duty buried in that power of attorney to notify the bank. that she's died.
That she's died. Yeah.
Yeah.
So just know that. That doesn't mean the money is gone. We're still going to help you get that account and get it to the people who are supposed to get the money, but it's not via the power of attorney anymore.
Right. We want to make sure you get that legally.
Yes. We don't want any of our clients or their children committing bank fraud. So just stop. Okay. Now this is one that comes up in our practice. My parent has dementia, but they can still sign their name. So let's go ahead and update their estate plan. That is not the standard for can somebody update their estate plan. It's not, are they able to write their name on a piece of paper?
Right.
They have to be able to understand what it is they're doing. So they still have to have that testamentary capacity. They have to know, who their natural heirs are, what their assets are, what the consequence of what they are doing in updating their estate plan. So that's not always easy to determine. Do they have that capacity? But if they clearly don't, and the child is just saying, well, she can sign her name. No, it's not good enough.
Yeah. Side note, you don't have to physically be able to sign your name in order to complete an estate plan.
That's like lower down on the list. We can work with that.
Yeah.
We can work with, she can't sign her name because she's got arthritis or,
had a stroke, whatever.
Yeah. We can work with that, but we cannot work with no cognitive ability. So,
yeah. The other issue with that is if the child is bringing the parent in to update their estate plan, it can easily be deemed undue influence under the law, which means if anybody, in California, we have these lovely elder care laws, and what they do is shift the burden. So if you're being accused of elder abuse or undue influence in an estate plan, the burden is now on you to prove that you were not. And so it makes it much more difficult to prove that. Like, how do you prove you didn't have bad intentions? Most people don't, but how do you?
Yeah, if the burden of proof is on you.
Yeah.
Rather than on the other party. Yeah. And so we have to be really careful in those cases where the parent has questionable cognitive ability. And it might not even be questionable, but there's a diagnosis or, people are talking about, well, we think she has dementia. We have to be really careful because we don't want the family to have litigation. We just don't want that. So we've got to be really cautious in those situations.
Yeah. And so just to note on that, if you bring your parents in for an estate plan to any attorney, there should be a time where you are not allowed in the office.
You're going to have to leave the office.
Yeah. Doesn't mean you can't be there for all of it because they might need physical assistance, but don't be surprised or upset if you're asked to leave. It's not, they're not trying to be rude. They're just trying to, not get sued later for doing an estate plan that might be invalid.
Right. Okay. What's next?
The next one is I'm too young. I don't need an estate plan. I'm, 25 years old. I'm, child-free, carefree. I don't need an estate plan.
I don't own a house. I don't, I've just got a checking account and 401k.
Yeah. News. What if something happens to you? What if you're incapacitated? Who's going to pay your bills? Who's going to go to the bank? Who's going to call? Let's say you're in college. Who's going to help deal with making sure you're not failing out of a class because you're in the hospital? Or, who's going to contact them on your behalf? Or who's going to make medical decisions for you?
Right. If you're over the age of 18 and you don't have a healthcare directive, a power of attorney, it's very possible that no one will be able to do those things for you because your parents don't have the right anymore. They're not your guardian. They're not legally responsible for you anymore. So,
and you might not want your parents making those decisions.
And it might, right? More to the point. Yeah.
Here's the thing. If you're 25 and you're married,
right,
and you don't have an estate plan, it could be torn between your parents and your spouse. as to who gets to make legal decisions. And that's where we ended up with Terry Schiavo, the big case everyone knows about. But if you don't have that healthcare directive,
right,
you could run into that.
Yeah. So everybody over the age of 18 really ought to take care of this. Even if you don't have enough assets or really any kind of asset to justify a will or a trust, at least take care of the incapacity pieces is what I would say. So, I don't have enough assets for an estate plan is a similar myth that I think we go down that same path with people, yes, you still at least need to do something because we worry not just about death, but also incapacity. What's next?
The next is that Medicare will pay for my long-term care. So Medicare is what everyone is required in the United States to the national health care for everyone 65 and older. And long-term care is typically deemed as skilled nursing or 24-hour care, a nursing home. Sometimes they're called a rehab if it's a short-term stay. And they have long-term care versions of the same thing. Yeah.
And if you go into the hospital, you're on Medicare because you're over 65 and, because of something, let's say you had a heart attack or you were in a car wreck or something like that. You go into the hospital and then you get discharged to rehab because the hospital doesn't want to keep you, but you're not really ready to go home. So they discharge you into a rehab. Medicare will pay for some of that for a while as sort of an extension of your hospitalization. But at a certain point, Medicare stops paying. And at a certain point, even if they're paying, they're only paying a small part of it. And you've got a very large copay is what you could call it. But Medicare doesn't pay for, what we would refer to as long-term care or custodial care. You've gotten old, you can't do things for yourself anymore, and you need assistance. Medicare does not pay for any of that. That is a common misconception.
And there's no ABC that pays for that. Like you can't buy into an Advantage plan that also covers that.
Right. Yes, you would have had to have purchased a long-term care insurance policy, which is a totally different animal from a Medicare Advantage or, whatever Medicare supplement. None of that comes under Medicare.
Yeah. And you can find a previous podcast about long-term care insurance on our website.
Absolutely. Yes. There's lots of resources about Medicare and other government benefits on our website, and anything that we kind of touch on here, we'll try to pull together the resources that we already have on our website, and you'll be able to find those in the show notes for this episode. So sort of related to that, a similar myth, but a little bit different, is Medi-Cal pays for assisted living or memory care. I can't even tell you how common this myth is when people meet with us, because mom is now, not really able to care for herself. She's got dementia. We think we need to put her in a memory care. They are shocked to know that even if they qualify for Medi-Cal, it's not going to pay for that. It doesn't pay for assisted living. It doesn't pay for board and care. It doesn't pay for memory care. All of that stuff is private pay. You've got to pay privately. And that means either you've saved a bunch of money or you purchased long-term care insurance.
Yeah. Medi-Cal is only going to pay for that skilled nursing. They'll pay for the long-term care and they'll pay for some in-home care, but it's not 24 hours. I don't even think it's 8 hours a day, frankly. Yeah. And, most people don't realize that along the lines of care where you have, independent living, assisted living, memory care, skilled nursing, home care, memory care and assisted living are the same. They're the same. Memory care is just a wing on the assisted living facility. That has locks and wander guards that they wear.
It's more secured. Yeah. Yeah.
But in terms of the level of medical care and the fact that it's a la carte, like assisted living is where you pay room and board, some cleaning and some laundry. But if you need extra care, like transferring from a bed to a wheelchair, or you can't dress
Showering.
yourself,
Mhm.
showering, that's all extra. And
Right.
insurance doesn't cover that. So unless it's long-term care, unless you have long-term care insurance, regular insurance is not going to cover that.
Right. Okay. Okay. What else?
The big one I see a lot is if I die without a will or without an estate plan, the state will get my assets.
Yeah. That's I mean, people, at least they get that, yes, it can be very expensive to die without an estate plan, but it's not because your assets are going to the state of California, right?
Yeah.
It's usually it's because somebody like us is going to get paid a lot of money to do that probate. It's the attorney's fees and the executor's fees really that eat up the probate estate. And they don't get all of it. They just get a small percentage. I say they, I mean, we are attorneys. Yeah. So, and we do probates. We only get a small percentage, but, a small percentage of a large asset, like $1 million home is a lot of money.
Where there's no cash. It's just $1 million home. How are you going to pay that?
How you pay that? Yeah.
You know.
So, yeah. So it doesn't go to the state, but people are correct to have this kind of fear of how much it will cost. It does cost a lot.
And that is the plus of the probate code, is that if you don't have an estate plan, the law says who gets your stuff. So it's not that it goes to the state of California. It'll go to whoever your heirs at law are when you die. And I think that gets mixed up with what we call when an asset gets escheated to the state. And that is just like unclaimed funds. Like if you go to the state controller's office and type in your name, there might be unclaimed funds because you forgot to get a deposit back on your water meter 50 years ago. And that, because you never claimed it, they hold on to it for so long and then it goes to the state. It doesn't mean it's not yours.
Yeah,
they just
the state is holding
it
it for you, and you can come claim it anytime you want, but that's where you would find it.
Yeah.
Okay. So the last one, I like this one a lot. It comes up a lot.
Yeah.
A lot. If I give someone more than $16,000 in a year, I have to pay gift tax. So
that's a fun one.
You don't have to pay gift tax until you get beyond your lifetime gift allowance or gift exemption, which is the same as the estate tax exemption. So I think by now, all of our listeners understand that there is an estate tax exemption. You can leave up to your exemption amount and not have to pay estate tax. This year, it's 12.05.
It's 05 or 06.
Yeah, $12.06 million. So you can give all the way up to $12.059 million and not have to pay estate tax. However, if in any year you give more than that $16,000 annual exclusion to a person, you have to declare it. You have to let the IRS know you did that. You file a gift tax return, but you don't pay tax until you get above your lifetime limit.
Yeah. The IRS just wants a record so they can make sure you don't go above your lifetime limit.
They want to track that. They want to know who's above and who's not. So yes. And the other thing is, I'm just going to say this now, it's $16,000 this year, 2022. Last year, it was only $15,000. It's adjusted for inflation. And guess what? We have a lot of inflation right now.
So who knows what it's going to be.
Yeah. So last year it was 15. This year it's 16. Next year it is going to be 17,000. The IRS has already told us that.
Yeah.
That's how much inflation we have. Usually it takes 4 or 5 years for it to go up in this $1,000 increment. This year it's 1 year.
It's been 15. It had been 15,000 for quite a while, I think. Yeah.
And then it went to 16 and now bam, it's going to 17 after just 1 year. So in case anybody didn't realize that we have inflation, you're not shopping where I'm shopping, I guess. Okay, let's see what audience questions we have. This requires me to scroll up and just make sure I don't miss any. I don't like to leave any of our viewers, our faithful viewers, out. If they have questions, I want to make sure to answer them. Okay, so here we go. If you have a common law marriage in another state, what happens when you move to California?
It depends. We have community property and separate property in California. And if you have assets that you acquired in another state, they can become quasi community property and quasi separate property. But if you're not married in California when you die, you're not married.
Okay. Well, so here's what I'm going to embellish that a little bit.
Yeah.
If you have a common law marriage, let's say you live in Texas long enough for that to be treated as a common law marriage. That's a marriage in the state of Texas. That is a marriage. And then if you move to California, California will recognize any marriage that comes in. We would not recognize it as a common law marriage if it's based in California. But if you come in married under Texas law, you're not unmarried just because you moved to California. So we recognize it. What is that full faith and credit law? It's somewhere in the Constitution.
Yeah, it's in the Bill of Rights.
The states have to honor each other's laws.
Yeah.
And that's what the Constitution says. So you would be considered married in California. The other thing is the federal government recognizes common law marriage too. The federal government leaves that whole marriage business to the states. And if the state of Texas says these people are married, the federal government says, cool, we get that. So all of the married tax laws apply to you. They apply differently if you are in California or in Texas. So so you're still married if you move to California, I guess is what I would say.
It was a good thing we asked that question after Obergefell, because then it would have been a little bit more difficult to answer.
Well, okay, I got another question. Can you set up a trust to protect yourself from creditors? Can you set up a trust to protect yourself from creditors? Because we said the estate planning trust that we use doesn't protect you from creditors, but can you set up a trust to protect yourself from creditors?
You can. You can set up an irrevocable trust. I don't know what I think most people don't understand what that actually entails. And typically that is gifting all of your assets away to someone else who's managing that trust. And you are no longer a beneficiary typically or have any control over those assets anymore. That's what makes it available to creditors, is whether or not you have any control.
Yeah. And in California, we're very strict about that. If you're going to set up a trust in California, that's an irrevocable trust that is protected from your creditors. You give up everything. You can't benefit from that property anymore. You can't control it. So people can set up asset protection trusts in other states that allow the person who set the trust up to also be a beneficiary. Whether or not that's going to do you any good against a creditor here in California, you got to talk to asset protection lawyer. But so it is possible. It is possible, but you might not like it.
Yeah. I mean, usually with clients, when we explain what an irrevocable trust entails, they're like, no, never mind.
I don't want to do that.
Yeah.
It's complicated. Yeah. You have to have a trustee. You have to file a tax return. There's a lot to it, and you've got to honor those laws. Otherwise you set it up and the creditors still can get it. Right. So you got to be really careful. However, it is possible to set up an asset protection trust for somebody else. You can take your money, stuff it into an irrevocable trust, and it will provide creditor protection to the beneficiary as long as that beneficiary is not you, so it's somebody else. So we actually do that a lot for our clients in estate plans.
Yeah.
And who want their children to have creditor protection. So that's
or my favorite, the protection from the spouse that they're not married to yet.
Yes. A spouse is just another variety of potential creditor. But you're right. Yeah. That's probably the most common thought that flashes through the client's mind when we talk about creditor protection. They go, "Oh, you mean like my son-in-law?" Yeah, him too. Okay. I think that's all the questions. I hope I didn't miss any. I'm going to just remind you, you can go to the show notes on our website for this episode, and there will be other resources kind of related to what we've been talking about today. You can always go to our website. There's a ton of resources there. And for those of you who are listening live, we are doing our Trust Administration 101 webinar for continuing education for our financial advisor and CPA friends. That's on October 28th. And just go to absolutetrustacademy.absolutetrustcouncil.com. If you want to register, it's free. It's 4 units of continuing education, and you're going to learn even more about trusts and trust administration. That's next Friday. Okay. If you're not watching us live, too bad. By the time you're listening to this, it already happened. But and maybe we'll just edit this out of the tape. I don't know. Madison, any final
thoughts? Would just say, if you have questions or you're worried that something that you think, because you heard from a friend of a neighbor of a sister, that there's something particular about an estate plan that you think just ask. I mean, because sometimes that little tidbit that's not true colors the entire way you're thinking going into an estate plan meeting. And I think it's better to lay it all out first. It makes things a little bit clearer. Yeah. There's a little less what ifs.
Always good advice. If you don't know or you're worried about something, just ask. Okay.
And tidbits from friends, their estate plans might vary wildly from yours, or they have a completely different situation. So I think that, to take all that with a grain of salt and ask your attorney about your particular situation.
Right. Very good. All right. Well, thank you everyone for joining us today. I hope you learned some things and got some things out of your mind. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.